So welcome back, everyone. Thanks so much for coming back. It's really nice to stretch a bit and get some refreshments for our in-person. So I crunched some numbers and basically we're gonna have to shave off 30 minutes from our dinner break or our 1 hour break, unfortunately. And then we'll be back on track for the breakout sessions. So that's the interactive breakout session. So really appreciate it. So we'll kick off our plenary session 2. And this is where we discuss the good practices to increase confidence in the formal justice system. And I'm very pleased to introduce our moderator, the Honorable Dr. Robin Layton. She's just so dynamic and fantastic. So, she was a former Justice of the Supreme Court of Australia and is currently the adjunct professor at University of South Australia. And she's also one of our key experts for the our technical assistance. So I'll hand it off to Robin.
Thank you very much. And yes, welcome back. And I'm going to indicate that I'm going to be terrible on time. And by that, I mean the guillotine will come down. So first of all, thank you all for coming back, those of you that have come back and those of you that may be joining. As you know, this is on good practices in increasing confidence in the formal justice system. And we have 5 excellent panel contributors from a variety of backgrounds. We have 3 judges. We have an experienced senior legal advisor from the IDLO. And we also have our wonderful, I'm sorry, I'm just making sure I've got something in front of me that I have. Yes, our fabulous documentary maker and anthropologist, Miss Shah. So again, we have 8 minutes for each panelist. And at the 7-minute mark, a gong will sound. And that is going to be the beginning of the swan song at that point. So first of all, if I could go to the first of our panelists, and it's Justice Ananda Mohan Bhattari from Nepal. So as he is coming up, I'll introduce him. He is a justice in the Supreme Court. He's authored many books, and he's handed down many landmark decisions concerning the Constitution, human rights, gender justice, and criminal. And he is going to talk with us today about some of the innovations that have occurred in law and practice in Nepal. So the first question for you, Justice, is over recent years, Nepal has made many great strides with regard to the Constitution and other laws. Would you briefly give an overview of some of that and give some examples related to domestic violence, sexual harassment, and protection for women? If you could answer that question first. Thank you.
Thank you, Chair. Am I audible? Hello?
Yes, you are, and we can hear you.
Thank you. Thank you, Chair. Thank you, panelists. It's a great pleasure to be to participate in this symposia. And as to the question, in recent times, 3 of parallel developments have taken place in Nepal. The enactment of Constitution, the latest one. In fact, the journey started in 1990 when democracy was established in our country. The court was given the power of judicial review, and we started getting a very bold framework of right. The latest constitution is was promulgated by Constituent Assembly in 2015. But when we look at gender justice issues, we need to go back to start with the 1990, when courts really began to look into international human rights law and taking inference from international human rights law, started issuing orders. For instance, in the first decade, courts recognized equal right to property of women. Then non-discrimination in workplace, and marital rape was recognized as a crime. These developments were later taken into the Constitution itself. So the 2015 Constitution has a very bold framework of right, so far as gender justice is concerned. Right of women against violence, right of women to equal property right, on family lineage, and so on and so forth. Right of the victim to information, participation in trial, compensation, and rehabilitation. These were also recognized in the Constitution. Further, the Constitution also provided for inclusion, social security, mainstreaming of gender in the political process. These are considered as very good development in Nepal. So, and around that time, some acts were promulgated by Parliament. For instance, Domestic Violence Act is a pre-constitutional act enacted in 2009. Then after the promulgation of the Constitution, the second step was taken by the Supreme Court in revising our civil and criminal codes. Previously, we used to be governed by a very narrow framework of law. Now, this is a very comprehensive code that has a very strong bearing on gender justice, and also we also have a separate law on sentencing. So sentencing is not just finished on the same day as conviction is made. We conduct a separate hearing for on sentencing. These are the new developments. And then Victim Protection Act, that act was enacted in 2017. I refer to codes. These new codes, Criminal Code, Penal Code, Procedural Code, and the Sentencing Act. These were brought out in 2017. And then Children Act. This act was there even before the Constitution, but looking at the provision of the Constitution and development taking place in international human rights law, especially CRC, a new Children Act was enacted in 2017. And in the year 2017, we also brought out a new act on Safe Motherhood and Reproductive Health Right Act. And then there are two more acts which have a strong connection with gender justice: Witchcraft Accusation and Punishment Act, and Sexual Harassment Prevention Act. These are the new developments that have taken place in the last couple of years in Nepal. This is generally the legal framework that I wanted to bring to the August gathering. Thank you.
Thank you very much. Nepal has certainly taken a very comprehensive approach, and you're well ahead of many countries. So well done to Nepal for doing that. Could I now come to the second question, which is, could you also share how sexual offences, including rape, domestic violence, and trafficking, are dealt with under your new codes, and how gender justice is achieved for women and girls in practice?
To this question, I would like to say that being a small country is an advantage. An advantage in the sense that when you move things and develop consensus, it is not that difficult to bring out legislation or raise the issue in the court of law. Coming to how we have done on how we have been doing on gender justice, I will not limit myself to the gender-based violence. It has to be looked from a very broader perspective. For instance, equal right, guaranteeing equal property right to women. In a rural country and agricultural country like Nepal, where the most of the capital lies in the land, real estate. If you do not give equal share to this real estate and property, land property, then there will be asymmetrical relation always. So therefore, recognition of equal right to property was a landmark initiative of the Supreme Court. And in conjunction with that, the court also recognized right to tenancy, right to inheritance, equal right to inheritance, all these things. Another issue that came up to the Supreme Court was right to identity. Till a few years back, children could get citizenship in the name by producing document of their fathers. Mothers did not have a right to grant citizenship to children. Now the Supreme Court said, based on the provision of the Constitution, no, children can apply for citizenship based on the citizenship of their mother. So this right, this recognition really is the problem of children who were brought up by single mothers, or whose family was disturbed, family relations were disturbed. Another is recognition of marital rape as a crime. This was the initiative taken by the Supreme Court. Later, it found a place in the Constitution, and now this is penalized by in the new code. So the punishment can go up to 5 years in marital rape. And then
could I just ask you to pause there for a moment, just bearing in mind time. I was going to be very fierce on this, so thank you for that. And if I could just move on to compensation, and in particular with regard to gender-based violence. Could you tell us something about how that is dealt with in the sentencing process in Nepal?
On this, I should say that now compensation is an overarching concept in the criminal justice. In every sort of crime, if there is a victim and the case is brought to the court, it's the duty of the judge to award compensation. And by compensation, also I also mean interim relief. Interim relief such as medical expenses or cost that has to be borne by victims during the trial. These are also covered by the Compensation Act. We have a separate Compensation Act based on the provision of the Constitution, and the code also comprises provision for compensation. So while conducting a sentencing hearing, the judge looks into the victim's perspective and awards compensation. And in the last 2 years, I have got the report that 30 million Nepali rupees has been paid to the victims to compensate them. This has also taken a momentum in Nepal.
Well, thank you very much for that, Justice. And we have very much enjoyed your presence today. I understand you may have to leave before the end, but thank you so much for your contribution.
I should. I'll be here till 10:30 Nepal time. Thank you.
And if I could now move to our second panelist, who is the Honourable Judge Robin Tupman from New South Wales in Australia. And she has been a judge and still is a judge in the trial court in New South Wales in Australia. And she's particularly been involved in setting up a child sexual offence evidence pilot scheme. And she's going to be largely contributing to our session today about that. So Justice Tupman, if I could ask you, you've had a long interest in children's law and sexual assault. Could you share with us this important work that you've done with regard to the pilot scheme and explain a little of how it was set up and why?
Thank you. Thank you very much for inviting me to participate. I'm very pleased to do so. There were long criticisms leading up to 2015 in New South Wales, as there have been over many jurisdictions in the world, that the experience of children who claim to have been sexually abused was not producing the best evidence, and the court system was re-victimising and traumatising the children. This was something that was being done, followed up in the UK, and there was task force. There were several task forces in New South Wales, and this particular one decided that they wanted to introduce a pilot evidence program, so that all of the evidence of children, not just the evidence in chief, which is what we'd been doing for a while anyway, but all of the evidence of children would be pre-recorded, dealt with as quickly as possible after they were committed to trial for trial to our court, and then actually played as, I call it a product, but nonetheless played as the evidence of that witness at the subsequent trial, which could well be months down the track. The purpose of it was, of course, to try and reduce the trauma to children, and to try to have the best evidence available, because it was as quickly as possible after the charges had been laid, and we didn't then have the problems of which we are all aware of children, particularly young children, having memory issues after a considerable period of time. It could well be 18 months to 2 years or so before the trial got on. And then young children in particular would forget a lot of the surrounding detail. That was said to be inconsistencies, and it meant that you weren't getting the best evidence possible. We've long had in New South Wales, since the early beginning of the early 2000s, alternate means of children giving evidence. They don't have to give evidence in court. They don't have to confront the person who they're accusing. Most of the time they give their evidence from closed circuit television rooms. But this was a real innovation. It was twofold. First of all, giving all of the evidence all at once, pre-recorded, and hopefully never have to come back again. And in fact, there's a provision in the legislation that says children in those circumstances can only be recalled to give further evidence with the leave of the court, and a practice that leave should only be granted sparingly. And that's the way it's happened. And then the other arm of the program was to introduce the concept of intermediaries, which had long been, which had been in place in the UK and a couple of other parts of the world, but they're particularly people who were able to effectively translate children, not from one language to another, but to assist to ensure that children's evidence could be understood and that children could understand the evidence. Again, the whole point being reduce trauma and ensure that the best evidence available was in fact what was being given. It had a political imperative at the time. It was supported by the government, and it could only have happened if, I think, if there hadn't, it would not have happened unless the government of the day had been behind it, because in our system, it required that sort of impetus to get it up and running.
Thank you. And how effective has that been found to be? Has there been any evaluation of its effectiveness and whether it's fulfilling its purposes?
There has been. The last evaluation that I have seen was 2018, I think it was. No, yeah, 2019. 2019, and look, it seems to be effective. Of course, it really all depends on how you define effective. I know that some in the community might define that as being the number of convictions obtained. As a judge working in a criminal justice common law system, it doesn't seem to me that that is the right way to define effectiveness, because it still has to be proof beyond reasonable doubt in a common law jurisdiction. What it has done, however, it has been found to work in terms of reducing the trauma to children. Their evidence is being given more quickly than it ever was, and there are very few occasions on which they're required or there's any application for them to come back. It's also had a culture change impact on the profession as well. As you can probably imagine, the defence bar was not particularly fond of this initially, because barristers seem to think that everybody has to be all in court at the same time, and it was all never going to work and it was going to be terribly complicated, some of which is true, but they've actually come round most of the time to seeing that it does work and that people are not necessarily being convicted when it's not appropriate for them to be convicted. One of the things that seems to have happened, although it's apparently early days according to those who are evaluating it, is it has actually increased the pleas of guilty for these sorts of offences. And we had very few pleas of guilty for these sorts of offences because our penalties are quite high. So, you know, there's not a great deal of reason to plead guilty to these sorts of offences because of the penalties being so high. But there has been an increase, and that is said to probably be as a result of the improved quality of the evidence from the children. And that we've only got it in 2 places. It's a pilot. We have it in Sydney and in Newcastle, which is a city about 100 kilometres north of Sydney, a fairly big area. And it does seem to be working. The intermediaries in particular are being well regarded. But there's room for improvement. Some of the defence bar is still not 100% happy that everything is as fair as it should be, and I think that sometimes that's probably right, and we need to be very careful about that. But yes, it's been evaluated, and it's been continued now until the end of June this year. I'm not quite sure what will happen. But the other thing I should have said is that part of the program was to introduce 2 specialist child sexual assault judges. And they are largely the 2 people who do most of these pre-recordings now. And I no longer run the program. It's kind of evolved now, and it's being taken over by the more junior judges who've now become the specialist judges who are running it. That seems to be working well. It's quite resource intensive so far as the court is concerned, however, which is amongst the reasons I have no doubt that so far the pilot hasn't been extended beyond the 2 cities where it's running.
And when you talk about resourcing, what are the particular things that need resourcing with this system?
Well, the first of all is judges, because it really means that you have 2 judges who largely spend their time doing these pre-recordings. And it's not just the pre-recordings, but the whole of the system introduces a ground rules hearing, which involves the intermediaries, which happens as a first step so that everybody is on the same page, Defence, Crown, everybody, about what particular needs a particular child might have in terms of understanding questions, how to put questions, and all of those sorts of things. So that needs to be not adjudicated on, or at least presided over by a judge. And then the pre-recordings as well need to be presided over by a judge. So if you think about it, that means that there are 2 judges who can't do anything else, more or less. They do some of these trials, but they don't have to do the ultimate trial. So that's 2 judges and their court staff. There's a fair bit of technology involved that has to work well, and that's been one of the criticisms, that it hasn't universally worked well, that some of the quality of the recordings isn't good. And there was quite a few teething problems with the technology, which we largely overcame. Also, the intermediaries need to be high quality, and they're paid. They're obviously paid by the government. And so they're the sorts of resources. Yeah, that's what I'm talking about. Yeah.
Thank you. And my final quick question for you is there anything, a personal anecdote you'd like to share about your experience?
Well, sometimes you never quite know whether what you're doing is working or not, and how best you would assess that as a judge. I did one of the very first pre-recordings because I thought I'd better do it myself just to make sure if I knew how it was working. And we work very closely with the specialist police unit that deals with child sexual assault, the child sexual assault police unit. And it's very important that everybody, all of the stakeholders in a system like this, are all work together, and that nobody feels that they're left out. So I work quite closely with the police to ensure that they provided all of the evidence, that everybody had everything on the same page. They got back to me after the first one that I did with some feedback. That evidence was given by the young girl. She was about 14, I think, something like that. She'd already had her evidence in chief pre-recorded, but she had all her cross-examination pre-recorded. It was all done in court. All of the objections were dealt with and taken, and the feedback to me from them was that the parents rang them and said, "We're so pleased that we agreed to do this. We're a little bit reticent to start with, but can I just say how great it is, because it's now done. it's over and done with, and she can forget about it now and move on with her life, which is, of course, one of the reasons why we did this. To be honest, I don't even know what happened to that trial. It was dealt with by somebody else, not by me. And probably, from what I know of the evidence, the person probably got convicted, but I don't really know. But it was nice to know that it had the desired impact for her, for the victim of the, or the complainant.
Well, thank you very much for. I'm sorry, Judge.
Can I just say that I think Nikita has a whole bunch of the legislation that
don't you worry about the questions.
No,
we'll do those at the end.
Okay, there's a lot of legislation. I gave them to her, and that can all be shared with people if they want to see what we did to put into legislative effect. Okay.
Sure. Thank you so much for that contribution, and I'm sure there'll be questions later. If I can now come to the third of our panelists, and it's the Honourable Judge Shahseeb Saeed from Pakistan, and he's occupied many positions in the jurisdictions of Punjab, and also he's worked in the Punjab Judicial Academy, and he's going to share with us today his experience with the before, during and after of the setting up of the first gender-based violence court in Lahore. So my first question, Judge, is you've been involved right from the start. What can you tell us about that?
Thank you, Robin. I'm grateful that you have provided me this opportunity to share my experience on this core issue. Yes, I have been involved right from the start for setting up the first pilot GBV in Lahore, following the combined initiative of the Honourable Justice Mansoor Shah and the ADB. Gender bias is a phenomenon which is invariably prevalent in our societies, but in patriarchal cultures, it is in augmented form. Let me say that gender bias discrimination in the criminal justice system makes substantial impediments, barriers to achieve access to justice for all. Let me show you a snap. Women faces significant barriers in achieving access to justice, whether they are victims, witnesses, alleged offenders, or prisoners. That snap says it all. Lack of conducive environment was the reason for low conviction rate. And victims were reluctant to appear in court for evidence, as observed by Justice Mansoor Shah in the recent judgment in the Supreme Court that in their case, it is the accused who is on trial, not the victim. Criminal justice system previously tend to focus on the needs of the predominantly male population of the offenders and prisoners. And Pakistan was no exception to that. But a sea of change was introduced in 2016. Prior to that, a special focus and attention given to the sensitive issue, and the situation was in shambles. The data collected and indicated that in Pakistan, only 2-3% of the rape offenders were convicted. In this backdrop, Justice Mansoor Shah, Honourable Judge Supreme Court, the then Chief Justice of the Lahore High Court, invited the Asian Development Bank to provide technical assistance on judicial training, capacity building initiative, and to establish the first ever gender-based violence court in Asia. Let me show you the snap of the training modules designed by the ADB team. The extensive training on gender-sensitive issues was an eye-opener to identify and realize the issues faced by the women, particularly victims day in and day out in the system of Pakistan. A program was conceived with the objective to provide a series of gender sensitivity and a gender-based violence training that emphasize understanding gender stereotypes, bias, and gender-based violence. The general atmosphere of the course, example, the loud environment, the imposing counsel, and the close proximity, that was the most important feature of the victim survivor to the perpetrator, combined to intimidate and traumatize victim survivors. There was also need to understand and address gender bias in court. In this regard, training was imparted to judicial officers in the Punjab Judicial Academy to sensitize them and realize the greater perception of the society of victim shaming. The most important feature of that program was that the practice notes were devised and guidelines were issued by the Honorable High Court for GBV courts for recording evidence of victim of GBV case. And the cases of rape trial and other GBV cases were put on fast track. The result of this effort was were amazing, and it made high evidence. In less than a year, the conviction rate for rape cases tried in a specialized court rose from 0 to 16.5%. Yes, Robin.
And can you tell us, since that time, what have you been doing with regard to, for example, the training of judges yourself after that preliminary stage during the setting up of the gender-based violence court?
Yes, Robin, I have received training from ADB team on this issue, and I have also imparted training to almost all the judicial officers in the Punjab Academy. The key issue to me and major obstacle was to change the age-old medical mindset of the society in general and institution in particular. Considering the socio-economic situation in Pakistan, it is a foregone conclusion that it is a male-dominated society. And as you know, that de-learning is always a challenging and cumbersome process. As I just said, that the main complication in imparting training was to change the mindset and gender stereotyping. The concept of, you can say that victim shaming and considering that the victim has some nefarious design behind these acquisitions is deeply embedded in Pakistani culture. It is estimated that less than 10% of the female victim survivors globally seek assistance from this system. Thus, our main focus by training of this officer was on gender sensitization, gender laws and culture of Pakistan, relevance of international standards and gender sensitized judicial conduct and GBV against women. Yes, sir.
And you have organized training yourself, is that correct?
Yes. Yes.
What have you done there?
Yeah, when I was posted as a district judge in district in Dera Ghazi Khan, as a head of district judiciary, the foremost daunting task for me was to let the judicial officers identify the problem faced by the victim of GBV cases. But doing various meetings with my team, having special focus on GBV cases, awareness was created by learning the patriarchal mindset and shed the preconceived notions. As you can see in this map, that one day seminar was held, inviting all the stakeholders like judges, police, prosecutors, doctors, and training was imparted by the ADB team with a goal in mind to provide a conducive environment for the victim in GBV courts. And that proved great help. Previously, there was no mechanism for providing congenial posture to the victim in her pursuit for justice. As you can see, I'm sharing this map. It's a juvenile rape victim. She was hardly 8 to 9 years of age, and she was provided friendly atmosphere. It was easier for her to record evidence without being intimidated. The presence of accused was secured online. It was done with the consent of the parties, and so victim-friendly judicial system was created to control the variables which become impediment in the way of justice. As you can see, that I was more concerned about the safety and comfort of the victim. Otherwise, she would have been too frightened. When this was done, she spoke with clarity, and the accused was convicted as per evidence on record. And after a gap, the conviction was passed in the case in Dera Ghazi Khan. Yes, Robin.
And finally, what do you think of the challenges now that lie ahead that can be improved in Lahore and Punjab?
At the cost of repetition, I have to emphasize that changing the mindset was the biggest challenge. Male humanistic societies deeply entrenched in macho culture are not ready to budge easily, let me say that. So to achieve this purpose, state actors of judicial system require more improving the ways of doing business, and technical and procedural hiccups lead to miscarriage of justice. Tedious process starting from registration of case, education is thorny road for victims. And there are some solutions and there are some suggestions. These are very exhaustive, and But after establishing, let me say this with pride, that after establishing the first GBV court in Lahore, and after the amazing results given by that court, and now we have 36 GBV courts in all districts of Punjab, and almost 100 GBV courts in throughout Pakistan. Although the threshold is not big, but we have taken steps in the right direction. There are some legislation on anti-rape laws, and we in Pakistan are committed to guard and improve this journey. Yes, sir.
Well, thank you very much for that contribution, and thank you for the wonderful work that you're still continuing yourself, but also judges in Punjab. So thank you so much, Judge.
Thank you.
If I can now turn to our fourth panelist, and here we're going to hear from two people. They are between them going to contribute. The first is Ria Shongsong, who is the Senior Legal Advisor in the International Development Law Organization, the IDLO, and she leads the work on justice for women and spearheads the integration of gender in the Organization of Justice and the Rule of Law programs. And today she's going to share her presentation with another IDLO colleague, who's Jagalan, who's a Mongolian lawyer and with extensive experience again in gender and access to justice. So first of all, we're going to hear from Ria, who is going to talk about a research report that's coming up on access to justice for survivors of gender-based violence in complex contexts. Can you tell us, based on the IDLO's programming and research, what some of the promising practices are as a result of the research that has been done? Ria.
Thank you very much, Dr. Layton, and good morning to everyone. I'm talking from The Hague, so it's still very early morning. Yes, we are currently finalizing a research report, and this research really focuses on how do survivors of gender-based violence access justice when they are in complex situations. So this is a research that we've done with Global Women's Institute at George Washington University. It's an original research looking at 6 countries, Afghanistan, Honduras, Papua New Guinea, Philippines, South Sudan, and Tunisia, with an asterisk on Afghanistan, as the research was actually conducted prior to August 2021. And it looks at overlapping challenges of a health pandemic, natural disasters, conflict, fragility, legal pluralism, organized crime, among others. Like within this context, which we all know is a very difficult scenarios, how do survivors access justice, and what are some of the best practices, or at least promising approaches? So the paper is of significant length, so I'll just highlight some of the snapshots from the paper. One of the first things that came out there is that specialized mechanisms or units, specialized police, prosecution, or courts actually can help gender-based GBV survivors, but only if they're adequately resourced, closely monitored, and are meaningfully embedded in the justice system. So there has been several studies around specialized systems and evaluations that mention they don't work. But this is primarily because they are not adequately resourced, they are marginalized within the system, and often not monitored as well. The second point I wanted to make is the primacy of protection orders that really came out a lot in the research. And here, protection orders, as we know, are very critical in building confidence in the justice system for GBV cases, especially when they're accessible, they're issued promptly, they're being monitored, and survivors are also offered support during the process. So,
could I just stop you there? I have a message that if you could please speak louder into the microphone, that would help. Sorry to have interrupted you, so that we can better hear you. Thank you.
I hope this is better. I'll try not to move. So protection orders are very important as long as they are accessible, issued promptly, monitored, and the survivors are actually supported through the process. So often there is a high rate of attrition between an interim protection order and a more temporary or permanent protection order. And there are many reasons for that, but one of the things that we've heard is primarily because of delay, lack of support, and even the use of mediation and informal or customary justice systems in between. The third point I wanted to make is around women justice professionals in the justice system are critical to increase confidence in the justice system itself. So not only are they important because it is a woman's right to participate in governance, including justice governance, but it also increases the representation of the justice system and supports broader access to justice. The last point I wanted to make is specialized mechanisms for data collection and review. And here we know that a key aspect of ensuring that justice meets internationally accepted standards is to regularly monitor justice systems, including the justice personnel. So monitoring and evaluation can address evidence gaps, identify best practices, inform law, policy, and practice. And this research that we've done is to contribute to that. But my colleague Jargalan will also talk about research that's carried out in Mongolia on trial monitoring and on justice chain on GBV. And I hope it would also provide more information around this types of work. So I'll stop there, and I'm sure I'm missing 5 other points on capacity building, legal aid, and a couple of items, but I'm happy to discuss it in the questions.
Thank you very much, Ria. And can you give us any indication when this report might be published?
I believe we are looking at the executive summary being published by July, and hopefully before the end of the year, the full report will be published, hopefully.
Thank you very much. Now, if I could turn to your colleague Jagalan, and if you could make your presentation.
Thank you, Dr. Robin Layton. I'd like to also express my gratitude to the conference organizers for the opportunity to share what we are doing in Mongolia in response in terms of response to gender-based violence and promoting victim-centered approach. So I would like to share with you my presentation. So IDELO began its operations in Mongolia since 2012, and since that time it is successfully implementing a number of projects and programs in Mongolia. So currently, IDELO Mongolia is implementing strengthening the response to gender-based violence in Mongolia project with the support from Government of Canada that aims to increase access to justice for victims of domestic violence that incorporates a victim-centered approach. So the key stakeholders of the projects include the Ministry of Justice and Home Affairs, Judicial General Council, National Police Agency, Prosecutors General Office, Mongolian Bar Association, and civil society organizations operating in the field to combat gender-based violence. Within the framework of the project component, to improve the response of justice sector to domestic violence, IDELO has conducted recently 2 studies that monitored and assessed application of a victim-centered approach in DV trials and DV cases along the justice chain. The objective of the studies were to conduct trial monitoring, analyze GBV regulatory and legal framework, and assess their level of implementation, and identify gaps and challenges, and to produce evidence-based report with recommendations on protecting the right of victims and improving supporting services for victims, and present the report to government agencies and stakeholders for further follow-up actions. So following the report of the study and stakeholders roundtable with government and civil society actors, and also including the representatives of the Human Rights Commission, the recommendations were distributed to all the justice sectors, key stakeholders, and to working group that was established under the Ministry of Justice and Home Affairs, which are now working at the moment on revising and making amendments to the laws on infringement and civil code. So the main findings and the recommendations came out from these two studies were related to the challenges in the legal framework, improving legal implementation, response of the justice sector and other organizations to combat domestic violence, and improving legislative framework. So in terms of concrete recommendations, for instance, came out from the trial monitoring. They were related to victim safety, victims' rights to access to information, and victims' rights to compensation. So in line with these recommendations, the Judicial General Council is revising the regulations on ensuring safety of trial participants, judges, courts, and court proceedings, and improving standards for informing complainants about the court schedules. And also the regulations indicate there's separate different entrances and exits at the court buildings. With regard to the right to compensation, so though the law on domestic, the law on combating domestic violence indicates 4 types of violence. The criminal code has a provision about just physical and sexual violences. And the other 2 types of violences like economic and psychological violences were left out of attention and were not legalized. So the Ministry of Justice recently revised the law on forensics, which creates the legislative environment for calculating, to include the psychological damages into the law, legalization of it, and for calculating psychological damages and providing compensation for DV victims. The recommendations came out from the Justice Chain research related to indigent victims, to providing legal assistance to indigent victims, and also use of victim-centered approach mechanisms by all justice sector actors, and also capacity building, training on the specific needs and vulnerabilities of DV voices and others. So in line with these recommendations, so the working group, which also is working under the Ministry of Justice, revised the law on legal aid in line and included these recommendations, and that include victims of domestic violence as beneficiaries. So the amended law expanded scope to include provision of legal aid to indigent victims of DV and child crime and child abuse crimes. In terms of capacity building, Ideal Law has incorporated a victim-centered approach in all practicing training to service providers, including police, lawyers, public defenders, and court administrative staff. And will provide also, in addition, we will conduct series of trainings for judges, police officers, and prosecutors in the fall of 2022. So this is the brief introduction of my presentation, and thank you for all your kind attention.
Well, thank you very much for that, Jaglan. It's very encouraging to see that such good research is done, but not only that there is good research done with good recommendations, but the recommendations are actually being acted upon. And that's a great credit. So well done for your organization, and well done for Mongolia for being so responsive. So thank you very much for your presentation, both of you. Thank you. And if I could move now to our final panelist, Sama Minelahan. I couldn't even get her name out last time, and I've worked with her over the last 4 years. What a tragedy that is. So Sama is going to talk to us today about how she uses her degree in anthropology together with her filmmaking experiences to actually challenge various forms of culturally sanctioned forms of violence. How she does that, how she uses the media, and then how she can use that with regard to training for judges and prosecutors. So Sama, if I could first of all ask you a question about your overall approach to addressing gender-based violence against women and girls through strategies aimed at prevention of violence.
Thank you, Robin. Thank you so much. As an anthropologist and a documentary filmmaker, I think in the area of advocacy, my background in anthropology has really helped me, because when it comes to addressing issues related to violence against women, I've tried my best to focus on culturally sanctioned forms of violence against women. And that's where my background in anthropology really helps a lot. So we still come across mindsets where if a woman has been raped, we don't focus on the fact that her self-worth, her dignity has been compromised. But in most of the societies, we hear that the family's honor has been compromised. So it is this particular mindset that I feel needs to be challenged through a culturally sensitive approach to advocacy and communications. Hence, what I focus on is working with local communities. When it comes to developing a particular strategy, it's actually the local partners who help us in designing that particular campaign. The short film that you saw in the beginning was actually made, the entire story, everything was developed with the help of our local partners in Timor-Leste. So that's what makes a particular tool more effective, when the local partners start to own that issue and are interested in using it as a tool for advocacy. So that's what I strongly focus on. And as you just mentioned, I focus on prevention, because I think that is the area that really needs a lot of focus when it comes to violence against women.
Thank you. And how do you know whether what you are developing as a result of the approach that you take is actually working? How do you self-monitor, as it were, the work that you're actually developing?
So, Robin, there are many ways of monitoring the impact of a particular campaign. But for me, as an anthropologist, the fact that the local communities or the civil society organizations are reaching out to us to use those tools for advocacy, that in itself I see as one of the indicators of success. Again, this film, I was pleasantly surprised where the main protagonist, Mana Maria, she said that I would like to use this film for advocacy in Timor-Leste and reach out to different local NGOs and organizations. And there were many challenges when we were working with Mana Maria, but in that process, her husband, her current husband, he has shown his support because of the way we were addressing this entire filmmaking approach. So I think when men come on board to address such issues, that I think really amplifies the message that we are trying to give out to people.
Thank you so much. And then maybe you can explain how you use some of that work with regard to the training of judges and prosecutors, because we have done work together.
Yes.
Along with Zari in Pakistan and also Afghanistan.
Yeah.
So can you tell us how you use your work in that?
Yes, so I've been lucky to have Sari and Robin on board, when it comes to developing modules. We have worked together in Afghanistan, in Pakistan, but now what we are trying like a different approach, given the scenario of COVID, we think that technology has the answer. And unless we combine technology and training when it comes to reaching out to justice sector actors, we won't be able to bring about a lasting change. So that's what we are focusing on right now. We are developing e-modules. And I think, again, for that, we have experts like Sari and Robin. But again, we are developing these e-modules in a very customized manner. For example, the one that we are going to use in Timor-Leste, you'll see that it has that cultural sensitivities, nuances that would apply very effectively in that particular geographical background. I'll just give you a short example of how we are designing this e-module. It's a very short, a few seconds clip. Cecile, can we show the first clip, please? Yeah. So the aim of these modules, and we have quite a few different topics that we'll be addressing through the modules, but the aim is to have interactive, very interesting modules that have podcasts, that have explainer videos, that have different tools that can also be used separately for advocacy by different organizations addressing the issue of violence against women. Now, another example I'll show and share with you. Again, we've been working with the local partners in Timor-Leste. And when it comes to addressing different social and cultural backgrounds, here you will see a glimpse of what we are trying to share with our audiences. Again, we came across these different scenarios. There is a saying where, as in many other communities, that when it comes to cases of domestic violence, that is seen as a private matter, although the law says something else. So there's one scenario that focuses on this particular issue. Then there's another scenario focusing on victim blaming. So you'll just get a glimpse of these two issues, but then the kind of questions that have been designed, like MCQs and everything, those then focus on issues like these that we have pointed out in the modules. The next clip, please. Yeah.
Ikan kanguru baku malu. The plater hit each other. Mai ve feto mak provoca mane atau halu violência, né? The women provocate the men to, therefore the violence was happening.
It is is absolutely essential to have a good understanding of the legislation within a total cultural and social context. Every country is different. Every level of development of law is different. And all of those things need to be taken into account.
So this was just a brief glimpse of what we are working on right now, and we are hoping to then replicate it in other countries as well. So yes, that's about it. And thank you so much, Robin. Did I cover? Yeah.
I'll talk to you later. Thank you very much for giving that glimpse, because this is still a work in progress for us. And we're going to work around hypotheticals and do all sorts, because we do understand that judges have often been trained sometimes to death, so to speak.
I know.
And they want a different approach.
Yes.
And this is why we're trying to make it engaging, to try and still be able to get across some serious messages, some serious information, but they can do it in their own time, in their own way, but still be interactive.
Absolutely.
So that has completed the panelists, but we still have some good time to enable us to deal with some of the chats and some of the questions. So here I'm going to go over to our facilitator. Nikita, can you tell me whether there's any chats, because I can't see them on my screen. Our screens went a bit unusual. Nikita?
Hi, just to let you know as well, Justice Batari has had to leave for his other engagement, but has been answering questions in the chat that were addressed to him. So we've got some questions being answered, but there are a few that we can ask the panelists now. So I'll start with one for Jagarland, actually. There's a question about a remark she made in the presentation on the role of mediation in customary justice system. This is from Arundhati, who's asking, may I please ask if the research that IDLO have undertaken find any evidence of victims of gender-based violence in certain contexts like rural areas seeking reparational justice through the customary laws or justice route more, and how prevalent is this?
Nikita, I think that question was for me, so I'm happy to answer it. Yes, and of course, Jargalad, you can also answer it from Mongolia's side. But in the research that was done, yes, we did find that women seek justice through customary justice systems or through
I'm sorry, you'll need to speak up, Ria. We can't hear you. Can you really talk loudly? Thank you.
Great. I hope this is better.
Better.
Yes, we did find a lot of women actually use customary justice systems, depending, of course, on mostly location, cost, different identities of women. In many of the countries that were in the research, of course, we had Afghanistan, Papua New Guinea, South Sudan, etc. So it was quite prevalent. IDLO also has a separate research around women and customary justice systems. And in there, we do have, there's a lot of research that shows around 80 to 85% of women in many of the developing countries do use customary justice systems for many many concerns, including gender-based violence. So, and another research on Somalia, which we supported the Ministry of Justice put together protocols for their alternative dispute resolution systems. And of course, in addition to land cases, women often bring gender-based violence cases before these ADR centers. So there was a need to develop protocols around how to handle these cases, including referral systems.
Thank you. Before I take another of the chats, I might see if there's one from the floor here before I go through what other chat questions there may be. Anyone want to ask a question from the floor here of any of the panelists? Otherwise, I'll see what's in the chat. Okay, I'll go back to the chat. Are there any others, Nikita?
Yes, there are. So we've got a question for Judge Saeed. And this question's just about the training that's being conducted for judges and for prosecutors and lawyers, whether such similar training being expanded to, say, police, journalists, NGOs, civil societies, whether that's something that that sensitization training is needed in order to raise the quality of justice in cases of violence against women and children.
Thank you. Yes, when we talk about the changing of mindset, it is meant to change the mindset not only for judges but also for all the stakeholders, that like police, prosecutors, doctors, scholars, and social NGOs, etc. Because changing the mindset of only judges is not sufficient. We have to change the mindset of other stakeholders. As I said that while answering the question, that I conducted a seminar in Dehradun, and I invited all the stakeholders. We should also conduct these seminars in district level, and we should invite the elders of the elder society in that seminar so that they can disseminate the information gathered in the seminar. That is very important. While also inviting doctors so that they can have the knowledge of the understanding of the latest law. For example, two-finger test that was unconstitutional, but not only by the High Court but also by the Supreme Court. Yes, I agree with the question that the other stakeholders, other state actors should also be invited, and their should also be their efforts should be done to change the mindset. Yes, that's my answer.
Do you want to add to that at all? Just
The
about
mindset
your advocacy.
Yes.
This is something that Sama may also contribute to, because she's been involved in some of the advocacy, which very much involves the civil society.
Yeah.
Sama.
So I completely agree with Shahzeb Saab. Actually, this came about with our discussions at the Judicial Academy in Pakistan. And one of the issues that the judges that we were going to train, they pointed out that it is the mindset that needs to be addressed. So whatever you are developing or designing, kindly focus on these areas, especially honor-related crimes, where honor is linked to a woman or a girl's body. So these were the kind of points that really helped us in developing an advocacy campaign. So yes, absolutely, changing mindset at different level is very, very important when it comes to violence against women.
And thank you. I think we have time for another quick chat question. Nikita?
Brilliant. This question is out to all the panelists. It's from Tavita asking, when dealing with domestic violence cases and when the court is making referrals to counselling services and mediation, are there any criteria about these services? The question comes because sometimes the people and organisations doing this reinforce stereotypes and expectations that promote gender inequality or justify domestic violence. And specifically, they're looking for examples from jurisdictions outside of the Pacific.
I wonder if I can turn to somebody from the IDLO. Ria, would you be able to contribute to that? And if you could speak right up to the microphone.
I'll give it a try. For example, CEDAW general recommendation actually has guidance. The latest one on gender-based violence, CEDAW general recommendation number 35, actually has guidance around the use of mediation. Also, the Council of Europe's Istanbul Convention also has guidance around that. We're pretty much, the shift has moved from no mediation, and I think this is listening to a lot of the voices of women survivors, to no forced mediations. And then the other guidance around that was that the series of caveats that are attached to any mediation are alternative dispute resolution that happens in cases of gender-based violence. So primarily, of course, support services has to be there. There are referral systems, sufficiently trained staff, etc. So without those in place, then mediation cannot happen. So I shared our work in Somalia, and actually that was one of the challenge where pretty much we were requested guidance on how to proceed on a protocol with ADR systems that are pretty much, a lot of cases on GBV are referred to it. And what do they need to do? Do they just say, we can't deal with it, go look for another, institution? Or should we ensure that they ensure the safety of the women, ensure referral systems, etc., and they're properly trained to handle these cases? So I would suggest GR 35 is probably a good guidance for this.
Thank you very much, Ria. I think we'll wind it up now. So in winding up, I just want to thank the panelists so much for the contributions they've made. You've done a wonderful job. And I just look forward at some point finding out some of the further progress that's going to happen in the cases that you have all referred to. So thank you very much. And also thanks to all of the people that have been participating generally in this. And I will say the session is over and hand back to Christina.
Thank you. Yes, this concludes our plenary sessions, and really appreciate all your commitment. So I just want to give some directions. So we're going to have a 30-minute break. So for Fijian participants, there's some food and you can walk around, and for virtual participants, you could take a break. So, just when you come back though, so you're going to be in your different sessions, right? So for this plenary session, you can keep the same link. So that's session 3C for CSOs and survivor victim advocates. But if you're, in the judicial session 3A, there's a separate room and a separate Zoom link that you have to log into. Same with the prosecutor session, which is 3B. So if you're in person, it's there's a separate room, and then there's a separate Zoom link for prosecutors. Otherwise, everyone just comes back to the same Zoom link and this main room if you're in session 3C. Okay, so have a great break. So 30 minutes. Thank you.
Thank you. Thank you.